Good afternoon, everyone, and welcome. My name is Andy Rosenheck, and I'm the Director of Investigations and Professional Conduct at the college. Before we get into today's agenda, I wanted to take a moment to acknowledge the ancestral lands around the province from which we are each joining the meeting, and to reflect on what that means for each of us. I'm joining the meeting from the college offices, which reside on the traditional territory of the Wendat, the Anishinaabe, the Haudenosaunee, the Métis, and Mississaugas of the Credit First Nation. As we come together today to address issues that relate to the college's public protection mandate, I think it's important that we recognize our privilege in sharing these traditional territories. In doing that, I commit myself to addressing systems of oppression that have dispossessed Indigenous peoples of their lands and denied their rights to self-determination. I remain mindful of these issues when I think of the work that we do at the college to protect students and to help ensure that schools are safe and inclusive spaces. I invite each of you to take a moment to reflect on your own relationship with this land and how you can contribute to our shared work in the education system. I'd also like to take this opportunity to thank you for joining us today for this webinar. This afternoon, we'll be reviewing key processes that are particularly important in your roles as you interact with the Investigations and Professional Conduct Department at the college. To guide us through this session, we have Janice Duggan, Manager of Investigations.
Good afternoon.
Patrick Winter, Manager of Intake and Analytics. Carly Thompson, Senior Investigator. Ben Drummond, Senior Investigator. And Nicholas Wallaschuk, Policy Analyst.
Good afternoon.
Each of them will share their expertise as they walk you through essential aspects of our processes. Feel free to ask any questions that you may have using the chat feature or the Q&A feature on Zoom. And throughout the webinar, college staff will pause between topics to address questions that you may have. We've also budgeted time for a Q&A at the end of the session. A recording of the webinar will be made available on our website by the end of this month for your future reference, or to share with other members of your staff who could not attend today's session. So with that, I'll turn it over to Patrick Winter to get us started.
Great, thanks, Andy. So welcome, everyone. On this slide is a list of the topics that we'll be speaking on today. We'll be speaking about employer reporting obligations. This is a refresher. We'll be speaking about member information on the public register, about members' self-reporting obligations, a refresher on the therapy and counseling funding program. We'll talk about professional advisories. We'll talk about transitional certificate holders and what you as employers need to know. And we'll talk about the sexual abuse prevention program. So starting out, the next few slides set out the statutory framework which govern your responsibility or your reporting obligations to the college. And it's a review of some things that have been provided in previous webinars. Such duties include an ongoing obligation to provide documentation or information to the college within specified timeframes. In a typical year, the college receives about 500 reports from employers under Section 43.2 and 43.3 of the Ontario College of Teachers Act. And if I could ask you to direct your attention to the slide on the screen, we'll talk about Section 43.2 of the Act. So if you as the employer terminate, suspend, or restrict the duties of a college member for reasons of professional misconduct, you must notify the college in writing within 30 days. You must report even if the member resigns while you are conducting an investigation or compiling evidence. So we all know what constitutes a termination or suspension of employment. However, it may be less clear what constitutes a restriction of duties. To offer clarification, some other examples of restrictions include removing a member from an occasional teacher list, a transfer of a member to another school for disciplinary reasons, or blocking a member from teaching specific grades or courses. Section 43.3 on the next slide is self-explanatory and sets out various scenarios relating to duty to report as they relate to certain types of criminal charges. So if an employee or former employee is charged with or convicted of a criminal offense involving sexual conduct in minors, or an offense that in the opinion of the employer indicates that students may be at risk of harm or injury, the matter must be reported to the college within 30 days. Section 43.3 also stipulates that if a member has engaged in conduct or taken action that, in your opinion, should be reviewed by a committee of the college, you should submit a report. Please note that this section is written in such a way that employers must report members to the college if they become aware of charges or convictions, even if the member no longer works for the employer. Moving on to section 277.40 of the Education Act, this deals with teacher performance appraisals. So if you terminate a member's employment following unsatisfactory teacher performance appraisals, you must submit a complaint to the college. This includes if a member resigns while on review status during the TPA process. So what should a report include? A report should include, of course, the name and college registration number of a member. It should also include a summary of the event or events that led to the report. It should have specifics of disciplinary action taken by the employer, and it's very important to provide sufficient detail. I'd like to take a little bit of time to focus on the second bullet point, a summary of events that led to the report. What we're looking for here is enough information so that we're able to make an initial recommendation as to whether an investigation at the college is necessary. We need a description of the event or events that led to the employer discipline, not just a general form letter with limited information. By description, I mean some details of what occurred. For example, rather than advising that a member used inappropriate language, it would be useful to know exactly what the employer alleges that the member said. If necessary, we'll follow up with you to get further information, but ideally some details should be included in that initial report. So on the next slide, we have an example of what not to do and what we prefer instead. So first, we have John Doe was suspended for 2 days for inappropriate communication and inappropriate physical contact involving a student. Instead of that, or in addition to that, we'd really like to see something like John Doe was suspended for 2 days for grabbing a student by the arm and dragging the student out of the classroom. He called the student stupid and yelled at the student to shut up. Now, in terms of how to submit a report, the information you're seeing is how reports may be submitted to the college. We prefer to receive reports by email. If you'd like a secure link by which you can submit large documents, please send an email to ipc@oct.ca, and the college will provide you with a secure link where documents can be uploaded. If you report by email, there is no need to send a hard copy of the same report. To ensure that the report was received, you may wish to ask in your reporting email that the college staff acknowledge receipt of your email. And we'd also like to remind you that the college has a fillable employer report form. The Investigations and Professional Conduct Department routinely looks for ways to make the reporting process easier and more efficient for employers of Ontario certified teachers. The fillable employer report form provides an outline of all information that we require when an employer submits a report. It can be completed and submitted along with any necessary supporting documentation at ipc@oct.ca, wherever a report is required. Please note that it's not necessary to use this fillable form. It's being provided for your convenience should you wish to incorporate it into your existing reporting procedures. If you have any questions about the form or if you'd like a copy of the form, feel free to contact our intake unit at ipc@oct.ca, and we'd be glad to provide you with a copy.
All right, so if the matter moves forward to investigations, you'll receive a letter and a checklist asking for further information relating to the report and also the member's discipline history with the employer. We'll speak more about the latter point in a few moments. You're required under the Act to provide the college with all documentation related to your report within 30 days of submitting your report to the college. We suggest you start assembling the information immediately following your report to the college to meet the 30-day timeline. When there are delays in providing the information to the college with no notice or explanation for the delay or a general unresponsiveness, the Director of Investigations and Professional Conduct or the Registrar may contact the employer's Director of Education or the equivalent at a non-publicly funded school. The college recognizes that there will be occasions when providing the information within the 30 days may not be possible. If that's the case, please contact the manager of investigations, whose contact information is set out at the end of this presentation, to discuss an extension.
Now let's do a quick review of the documents required by the college following an employer report. As noted, the college requires information and documentation pertaining to the member's previous disciplinary and conduct issues. Why do we ask for that information? Sometimes when an employer are reviewing a member's history, they discover that a matter that should have been reported to the college was not. For example, a member was suspended, but through an oversight, the matter was not reported at the time. This is an opportunity to alert the college to that prior suspension, or sometimes a member's conduct issue did not lead to a mandatory reporting obligation in light of the current report, but it may represent a pattern of misconduct. We're attempting to get a complete picture regarding the member in order for the investigation committee to make a fully informed decision. And what information is the college routinely seeking? We are seeking all underlying investigation information and documentation, such as principal and vice principals' investigation notes, witness statements, including those of any alleged victim, investigation findings and reports, disciplinary letters, and all relevant correspondence, including emails, texts, social media messages. Each case will yield different information that was gathered during an investigation, depending on what the allegations were. But what I just listed is typically found in all investigations. We also require the member's current employment status and the dates of changes to their status. For example, has the member retired from the board or employer? Has the member gone on a medical leave? The names and addresses and contact information for school and board staff who are involved in the investigation and all those affected students and student witnesses are also required. Also, please do not redact documents. If a matter is referred to investigation, the assigned investigator will redact the documents as appropriate before they are disclosed to the member who is the subject of the investigation. If redacted documents are sent, this will lead to the investigator sending a follow-up inquiry seeking the unredacted materials.
Also, most of you are probably aware that of the checklist that you receive when the college acknowledges receipt of your report and writes to ask you for the information regarding that report. The checklist sets out what documentation the college is requesting from you. If you're not familiar with the checklist, please send us a note in the chat and we'll get back to you with this information. Finally, I will add that as noted, when you receive the checklist, we ask for the member's discipline and conduct history. Often in response to that request, we've only received letters associated with measures taken against members. Although that's helpful, just as we would with a current report, we would also like to receive any underlying information related to your historical investigations. Basically, we're asking for the same information that we would expect to see in a matter being reported by you under your Section 43 reporting obligations. For TPA matters, the college will require a copy of all summative reports for the member and any materials relating to the TPA process, such as the principal's observation notes and improvement plans. You may wish to go to the employer's area on our website where you can obtain further information concerning employer obligations.
I'll just jump in here as we have two questions that were posed during this slide. So the first one asks, do you contact students to verify? I imagine we would need to let parents know first. And I believe this one came up when Ben was speaking. I don't know, Ben or Janice, if you need more context or if you want to take a stab at that.
Andy, did I hear correctly to say, do we need to let the parents know that we've asked the employer to disclose that contact information to us? Is that?
No, it asks if you need, do you need to contact students to verify? And then it says, I imagine we, the employer, would need to let parents know first.
Okay, so that's how I took that question. So the short answer is, in our view, you do not need to contact the parents to let them know that you're providing that contact information for the students because you're required under the Act to disclose the information that we've requested. As a policy, if you wish to do that as an employer, that's up to you. But vis-a-vis your obligation to the college, there is no requirement that you contact the parents. And I'm not sure I understood the verification piece. Obviously, the board would have the most up-to-date contact information for the parents of the students. So I'm not sure what the verification piece means.
So we've just received some clarification. So it's in relation to the last bullet point on this slide, which says that you want student contact information. So the last bullet reads contact information of board staff and students involved in the investigation. And so the clarification question is, do you reach out to students?
Yes, we will, but not directly if they're underage. We would go through the parents, and again, we wouldn't do that in every single employer report to the college. Those would be cases where the matter is very serious and is going to be referred to the discipline committee because the students may be required to give evidence. So it's not in every single case that we'd be contacting the students, but we do need the contact information.
Thanks, Janice. And one other question that came up in the chat is, if a teacher is reassigned to home while a board is conducting an investigation, should the college be notified?
I'll take that one, and it's a good question. And in fact, I think it steals a little thunder from a frequently asked questions section we have coming up in a few minutes. But the answer is, in strict terms, no. It's not necessary to report home assignments pending the outcome of an investigation to the college. If in your opinion it is something that should be reported immediately, I would suggest that you do that. But strictly speaking, that notification trigger does not occur until the suspension or the termination or the restriction of duties is done for disciplinary reasons or for reasons of professional misconduct.
Thanks, Patrick. Those are all the questions we've received to date. So Ben, I'll turn it back over to you.
Thanks, Andy. Note that any information you send to the college as a result of the checklist or as requested by an investigator must also be provided to the member within 30 days of sending it to the college. This is a statutory obligation with which all employers must comply. As previously mentioned, if you have any questions or concerns about sending unredacted materials to the member who is the subject of a report to the college, you should consult legal counsel for advice. You may also wish to go to the employers area on the college website where you can obtain further information concerning employer obligations.
Once you've provided all the information identified in the checklist within the 30-day timeline, the investigator will determine if any additional information is required. As indicated in the slide before you, the Act requires that such information be provided within 15 days of the employer receiving the second request. As noted earlier, it's important and appreciated if employers advise that they'll be unable to meet that deadline. There may be a good reason to request an extension, and the college is open to considering such requests. If you encounter any issues meeting the 15-day deadline for additional information requested by the investigator, please contact the investigator to discuss an extension. The college wants to keep the lines of communication open, so please do contact us if a problem arises with the timelines. Reminder that if there are any updates to the board staff, please update us at your earliest convenience.
So just some points to note. Please note that the timeline specified in the Act remain the same regardless of your academic calendar or closure period. Also, the Ontario College of Teachers Act does not allow the college to delay an investigation where there's an ongoing grievance or arbitration. The employer disciplinary process and the college's investigation process are two separate processes. While we may follow up with you to determine the status of a grievance, that's to ensure that we have all the up-to-date information and that it's been gathered for the investigation committee.
So let's look at a few frequently asked questions. The first is, should I send audio and video materials? The answer is yes. So as noted on the slide, the college receives frequently asked questions about what materials should be sent to the college. The college is often asked if audio and video materials should be sent. Any relevant audio and visual recordings must be provided. For example, this would include video recordings of a hallway incident or a video received from a student in relation to an incident involving a member. If the file size is too large to share over email, please let us know and we can send over a secure share file link to safely upload the audio and video files. The college is also asked about notes and what's required. The college requires any notes, whether handwritten or typed, related to the report, such as the opportunity to respond meeting notes, interview notes, principal's notes, vice principal's notes, etc. Please ensure the notes are dated and it's clear who authored the notes. Please note that settlement agreements between employers and members will often contain a provision indicating that the agreement can be disclosed if required by law. The Ontario College of Teachers Act is a law that requires that this information be disclosed to the college.
So I'll jump in again just with a question before we go to the next slide. So the question is, can you please clarify, are boards to provide supporting documentation within 30 days after submitting initial report or within 30 days from receiving the checklist from the college?
So Andy, I'll answer that one. It's 30 days from the acknowledgement letter that intake sends and I sign, and that encloses the checklist. So it's 30 days from there.
Thank you. So
Please
Ben,
also identify the date of each incident in question. This includes the month, day, and year. If the reported conduct occurred over a long period of time, please identify the date as best you can, or include a broader time period, such as in or about the spring of 2024, or in or about March 2024. As we mentioned, we would appreciate typed notes, or if that isn't possible, please just ensure legibility. I also want to touch on documents which are often sent to us in the form of screenshots. We often receive screenshots of electronic exchanges like email threads, text messages, and social media messages with information missing. Please be sure to identify how the screenshot first came into your possession. For example, on October 1st, 2024, a student named Jane Doe showed the school principal text messages she had exchanged with her teacher, John Smith. On October 2nd, 2024, the school principal took photos of the screen of Jane Doe's phone, which displayed the text messages. And here's another frequently asked question. Can the employer agree with the member not to report a matter to the college? So employers cannot enter into an agreement, including minutes of settlement with the member, which includes an undertaking that is contrary to your reporting obligations under the Act. For example, an employer cannot agree not to report a matter to the college under the Act that is a mandatory report to the college. Also, in settlement agreements, employers cannot agree not to fulfill its obligations to provide information to the college in relation to a report to the college. Your reporting obligations under the Act cannot be contracted out of. So any settlement agreement that agrees to remove an employer's reporting obligations to the college is invalid. While you as the employer may have settled the matter with the member by having, for example, the member resign from their employment, this does not end the employer's obligations to the college. Finally, please do not write to the college to advise that matter between you as the employer and the member has been settled, and you are requesting that the college close its file. The college will not do so. Under the Act, the college has a public interest mandate to govern the profession, and as part of that mandate, it has to investigate all allegations of professional misconduct, incompetence, and incapacity.
So the next frequently asked question is, should I redact the documents? We're often asked what information should or can be redacted from documents sent by employers. The answer is, please do not redact the documents. When the college requests information from employers, it's essential that we receive the information in its truest form without redactions. Oftentimes, we receive employer information with student names, ages, grade levels, and contact information redacted. We also receive employer information that has the contact information about the parents of the student witnesses redacted if the student witnesses are minors. I know I'm repeating myself, but please only send unredacted documents. We require this information for the purposes of our investigation. Additionally, the college sometimes receives employer information without the student witness contact information. Please ensure that the contact information is included. There may be a reason for contacting the students during the college's investigation, so that information is important. Some employers have voiced concerns regarding confidentiality over this type of information. We want to assure you that this information remains confidential. Contact information is redacted from disclosure made to the member. The college does not disclose student witness or student victim contact information. However, we do disclose student witness and alleged victim names. We provide that information to the member because the college has a disclosure obligation to the member during its investigation process. As a matter of law, the member is entitled to have all relevant information in order to provide a response to the complaint. When conducting an employer investigation, please do not give members or witnesses assurances of confidentiality. You'll be required to provide the college all interview notes and contact information as part of your statutory duty to provide information to the college. So as noted, the college is obligated to disclose all information to the member during the course of its investigation. Therefore, any assurances of anonymity should not be given to a witness or an alleged victim. Without that information, a member may be able to argue that he or she could not fully respond to the complaint. The college has received questions about sending password-protected documents. Please do not send password-protected documents to the college. The college email system is secure and confidential. And as stated earlier, the college does not require a hard copy of employer information packages. The college's strong preference is to receive an electronic version of the employer materials. Also, please ensure the documents that are sent are clear and legible.
So I'll jump in again because we've received a question with respect to this slide. So Janice, this one probably will be for you. So the question is, the college's view is, quote, no, in response to whether a board can enter into an agreement with the employee and not report to the college. Is it simply a view or a legally mandated position? I think we need to be clear and use language that clearly states the legal requirement.
Right. So that's a good point. It is the college's view, and it's based in the law. You cannot contract out of a legal obligation under the Ontario College of Teachers Act if you have disciplined a member in a manner that Patrick talked about earlier. That's a mandatory reporting obligation to the college, and you cannot enter into minutes of settlement that remove that mandatory reporting obligation. So it's the college's view, but it's based in the law.
Thanks, Janice. So I'll turn it over to Ben to continue.
Thanks, Andy. Just waiting for the slide there. What is the employer's reporting obligation when a third-party investigator is hired to conduct an investigation of a member? So the college receives employer notification where a third-party investigator has conducted the investigation. In some situations, the employer has entered into an agreement with the third-party investigator that permits the investigator to have ownership of its underlying investigation product. While the employer will provide the third-party investigator's final report, they will not, for example, provide the interview notes because of the agreement signed with the investigator. As noted, please remember your obligation to provide the college with information when retaining a third-party investigator. The difficulty for the college with not having the underlying investigation material is twofold. One, the member who is under investigation may argue they are not able to provide a complete response to the allegations. And then two, the investigation committee panel that considers the matter may not have all the information necessary to make an informed decision.
All right, now we'll turn to a few frequently asked questions relating to an employer's duty to report, that initial report. So do I have to report when an employee goes on a medical leave of absence? In and of itself, no, you don't. An employer's reporting obligations under Section 43 of the Act are triggered due to a suspension, restriction of duties, or termination of a member's employment for reasons relating to professional misconduct. Where the member goes on a medical leave of absence in the course of an investigation and you're uncertain whether the member's conduct constitutes professional misconduct, please report the matter to the college. Essentially, what we're looking for here is that if you believe that there is a risk that the college should know about, you do have that authority under Section 43.3 of the Act to report something to the college. Now, on the next slide, we arrive back at the question that we answered through the chat earlier. Do I have to submit a report to the college when a member is assigned to home pending the outcome of an investigation by the employer? The answer to this is, of course, it's not necessary to report that a member has been assigned to home pending an investigation. However, if the investigation concludes and a member faces disciplinary restriction of duties as defined in Section 43.2 of the Act, the matter must be reported at that time. And I just want to reiterate, though, that if you do believe that even if somebody is currently under investigation and you anticipate that the investigation is going to be lengthy, if you have reason to believe that there's a public interest matter in reporting it to the college immediately, there's nothing that prevents you from doing so. However, it is not mandatory.
We'll now move on to member information on the public register. So on some occasions, members of the public and employers identify teachers who are the subject of a report to the college by one surname, while the college records have the member using a different surname. This can cause some confusion about identifying who is being complained about. College staff make every effort to ensure that the correct member is identified, but it would assist matters if you could remind your OCT staff that they have obligations under the college's bylaws regarding information that they must provide to the college. In the next slides, we'll set out some of the information that members are required to provide to the college.
Section 19 of the bylaws sets out requirements regarding member names. The slide states the member's name on the registry shall be the name of the member's application for registration, subject to certain exceptions. When a member changes their name, they have an obligation to immediately notify the college of that name change. The college also sometimes runs into the issue of members not advising of their current employer. Section 25 of the bylaws and the information that members must provide to the college. This includes their current employer and the member's current contact information. Again, it would be appreciated if you could remind your OCT staff of these obligations.
All right, switching gears a little bit, we're going to talk a bit about a member's self-reporting obligations. So in 2020, the Ontario College of Teachers Act was amended to include new reporting obligations for college members. And this slide here outlines the section of legislation regarding a member's duty to self-report in relation to criminal matters. Members are required to report the following to the college: offenses, charges, as well as bail conditions and other restrictions. These reporting obligations took effect on December 8th, 2020, and failure to comply with these reporting obligations may be considered to be professional misconduct. And at this time, we're going to navigate to the college's website to show you where your teaching staff can submit a self-report. So this is the main website of the college, oct.ca. And we have a section over the top called members. And if you scroll over that, it brings up a list of options. Down towards the bottom, we have member reporting obligations. And if you click on that, it will offer a bit of a preamble about what those obligations consist of, as well as a link at the very bottom of that page to begin the process of making a report to the college. You can see the information here that we're going to ask for. It's a fairly limited, it's a fairly quick and non-cumbersome process, and you can hit submit down at the bottom, and that will automatically be entered into our system for follow-up. All right. So again, you'll see here the reporting obligations listed here if a member has been charged with an offense. And when self-reporting, the member must include, among other things, the charge, when the charge was laid, and the location of the court in which the charge was laid. Any bail or release conditions must be included in the report, as well as the status of any proceedings. It's important that the employer continue to report criminal charges or convictions to the college, as you do have a duty to report these outcomes or these charges under the Act. And some members may not always fulfill their obligations to self-report charges and convictions. So the college's mandate is to govern the profession in the public interest and to protect students. Posting a member's criminal charges, applicable bail conditions, and convictions helps the college to fulfill its mandate by alerting the public to members who may pose a risk to students. All right, and we're also going to talk about the college's therapy and counseling funding program. The college has introduced a program to help defray the costs of therapy and counseling borne by students who allege having been sexually abused by teachers, involved in child pornography, or prescribed sexual act. If a student has been sexually abused or was the subject of a prohibited act involving child pornography by a member of the college, help is available. Survivors, parents, guardians, and siblings can apply for funding to help pay for some of the costs of therapy and counseling. The college will make funding available to help cover survivors' costs for therapy and counseling to the tune of about $18,000. This amount is equivalent to what the Ontario Health Insurance Plan would pay for 200 half-hour sessions of individual outpatient psychotherapy with a psychiatrist. So if you or your staff encounter scenarios where it might be appropriate to make a student or former student aware of the program, please advise them to contact the college, and we'd be happy to provide information about applying for funding. The application and claims processes are straightforward, and college staff are available to help survivors in a compassionate and understanding manner. All right, so now it's quiz time. We have a few true and false questions for you, and there should be a pop-up that appears on your screen where you'll be able to answer the questions. So let's go ahead with first question. If a member self-reports a criminal charge to the college, the employer does not have to report it to the college. Question 2. Timelines related to documentation to be submitted to the college or a member following a report to the college are specified in the Act and can fluctuate as a result of ongoing grievances or arbitration. And question 3, employers are required to report when a member has been assigned to home pending an investigation. We'll give a few moments here to enter your answers. And if we've gotten all our answers in here, we'll go ahead and reveal the correct answers. Oh. There we go. All right, so if a member self-reports a charge to the college, the employer does not have to report it to the college. That, of course, is false. As you can probably suspect, a lot of members, when they're charged with an offense or if they're convicted of an offense, for one reason or another, notifying their regulator may not be top of mind. So in the interest of getting all that information to us, it is very important that you continue to report. Question 2, timelines related to documentation to be submitted to the college or a member following a report to the college are specified in the Act and can fluctuate as a result of ongoing grievances or arbitration. False, grievances or arbitration would not affect the timelines. And question 3, employers are required to report when a member has been assigned to home pending an investigation. Again, that's false. We've gone over that a few times at this point.
And Patrick, I'll just jump in. We've received a question while you were on this, I think during the quiz, that asked, can you share more about disciplinary restrictions of, can you share more about what disciplinary restrictions of duties could look like?
Sure. So the most common ones, of course, are suspension of employment or termination of employment. Those are the ones that we routinely see. There is a list under Section 43.2 of the Ontario College of Teachers Act, which outlines some other restrictions. And this can include things. I won't go through the whole list here. It's Section 43.2 subsection 6, but it'll talk about restrictions on the age of students, grades, or subjects that a member may teach or supervise, restrictions on a member's eligibility to teach without supervision. There are a few more there. Like you can see, the termination or suspension are the ones that are going to come up by far with the most regularity, but the other ones are outlined in Section 43.2, subsection 6 of the Ontario College of Teachers Act.
Thank you.
All right, so now we're going to provide a little bit of a heads up about a new professional advisory. The college has developed 9 professional advisories that provide practical advice to members on a variety of topics important to members of the teaching profession. We recommend that school administrators review these advisories on a regular basis with their teaching staff in order to maintain familiarity with their responsibilities in a variety of areas relating to their work. And in 2023, College Council endorsed the development of a new professional advisory focused on countering hate and discrimination. Ontario certified teachers play an important and influential role in learning environments and are uniquely positioned to help address acts of hatred and discrimination and their impact on students. The new advisory is a professional response to the significant increase in acts of hate and discrimination reported since 2020. And it's intended to help teachers recognize and collectively address incidents of discrimination and hate within learning environments, understand their professional, ethical, and legal obligations in creating a safe learning environment, and comprehend the extent of their professional and legal responsibilities as a teacher inside and outside of the learning environment, in person and online. And advisories are developed based on extensive input from teachers, education and community partners, as well as subject matter experts. We'll talk a little bit more about some key professional advisories that exist for you and your staff. And based on complaints and reports received by the college, all members of the profession should be familiar with the following professional advisories. The first one is maintaining professionalism in use of electronic communication and social media. And this advisory helps to clarify members' responsibility when using electronic communication or social media so they can govern their conduct and understand what conduct does not meet professional standards. Professional boundaries is important as well, of course, and this advisory highlights the importance of maintaining professional boundaries and provides practical advice to Ontario certified teachers at any point in their education careers. Professional misconduct of a sexual nature. This advisory helps to identify the legal, ethical, and professional parameters that govern members' behavior and to prevent sexual abuse of students and sexual misconduct. And the professional advisory on anti-Black racism. This advisory recognizes that Ontario certified teachers play an important and influential role in learning environments, and as such, are uniquely positioned to help address anti-Black racism and its impact on students. The advisory examines how Ontario certified teachers can work toward overcoming long-standing and historical legacies and break down deeply entrenched systemic barriers. All of these advisories are available on the college's website and can be downloaded as PDF files for distribution.
Thanks, Patrick. And I'll jump in once more with a question that we received during this slide. So the question is, there are scenarios where workplace investigation would warrant a disciplinary written warning, not suspension or termination, and a teacher is required to be transferred to another school location for the substantiated misconduct. Would that be required to be reported to the college for teacher transfer?
This is a bit of a scenario that does not come up in the legislation. You'll see the Section 43.2 of the Act is silent on transfers. It's our position that a transfer to a new school for reasons of professional misconduct or involving a disciplinary matter would be considered a restriction. But again, the Act is silent on that.
Thanks, Patrick.
Thanks, Patrick. From College Communications, you are no doubt aware that a new transitional certificate has been introduced. We're not planning on providing extensive information about the certificate, but rather some key points to be aware of with respect to an employer's obligations as they relate to reporting matters to the college. Transitional certificate holders are members of the college. They must adhere to the standards of practice and the ethical standards of the profession. Any transitional certificate holder that engages in professional misconduct is subject to investigation and discipline at the college if they engage in misconduct, and could result in public hearings and sanctions up to and including terms, conditions, limitations, suspensions, and revocation. They could also be subject to complaints of incompetence and/or incapacity. Transitional certificate holders are subject to college jurisdiction at all times, including on practicum and while employed as a teacher. Like any other member, transitional certificate holders may be subject to the employer's mandatory reporting obligations that we discussed earlier in the presentation. Employers are required to report to the college cases of restrictions on practice which arise out of a disciplinary process, as well as criminal charges and convictions that involve sexual misconduct or actions that pose a risk of harm or injury to students in the opinion of the employer. Employers may also report any matter that they think should be reviewed by a college committee. In short, any reporting requirement that was discussed earlier in this presentation applies to transitional certificate holders. It is critical that school administration personnel are made aware of mandatory reporting applicability to transitional certificate holders. School boards, in conjunction with faculties, are expected to provide appropriate mentoring and other supports for these transitional certificate holders while they are teaching on the certificate. We understand that the ministry is sending out guidelines to this effect with details on supports required. Like any other member, transitional certificate holders may face complaints from parents and other members of the public for conduct inside or outside the classroom, which may relate to misconduct, incompetence, or incapacity. Since January 2022, the Ontario College of Teachers Act has required all Ontario certified teachers and new applicants to the college to successfully complete a sexual abuse prevention program, or the SAP. The SAP consists of a series of video modules, each with a distinct focus on subjects that include information on how to recognize when a student may be disclosing that they have been abused. Between November 2024 and February 2025, the college provided all boards with the names and member IDs of their OCT employees who have not yet completed the SAP. Several boards have achieved full compliance with the SAP requirement. The college will administratively suspend a member's license if they fail to complete the SAP by July 2nd, 2025. If a member's license is suspended, they can no longer be employed as a teacher in Ontario's publicly funded education system. You'll note that members who are administratively suspended as a result of failing to complete the SAP will have the notation "suspended administratively" appear in the status section of the member profile page. Once they complete the SAP and pay the $130 reinstatement fee, their status will revert to good standing or another status if applicable. A historical reference to a member being administratively suspended will not be maintained on their member profile page. In other words, once the administrative suspension is expunged, no public record of the suspension will appear on the member's profile page.
Nick, I'll just jump in
Sure.
once more with a question that stemmed from this slide with respect to the sexual abuse prevention program. So the question is, do you send lists of non-compliance with the sexual abuse prevention program to independent schools?
The short answer is no. The non-public, the issue with that is that the college's registry does not allow for us to identify the independent school and the member being attached as an employee there. However, the member will have received correspondence from the college on numerous occasions, and particularly since November 2024 on a monthly basis. And those notifications will continue on a monthly basis until the suspension deadline of July 2nd, 2025. And those notices include electronic notifications, our social media, physical letters, and as well as updates to the college's website and the members portal. So we're using a variety of communication media to notify the members, but the short answer in respect to independent schools is no, we are not providing lists. It's strictly the publicly funded schools.
Thank you.
Okay, accommodations, extensions, and exemptions. Members can request accommodations to help them complete the SAP by contacting the Canadian Centre for Child Protection, or C3P. Some examples of accommodations include a written format to complete the SAP instead of the video-based module, an introductory video to the SAP, and access to a support telephone, including examinations by telephone. Extensions for current OCTs are no longer permitted by law, except for Ontario labor mobility applicants who must complete the SAP within 1 year of their certification date. And exemptions were never permitted by law and are not permitted now. The college recommends that you follow up with your employees who have not yet completed the SAP, as well as with their respective affiliate, federation, or principals council.
Thanks, Nick. So this brings us to the end of today's webinar. On this slide, you'll find a QR code that you can scan, which will bring you to a short 2-minute survey. And a link will also be emailed to you shortly after today's session. So I thank you in advance for taking the time to share your feedback, as it will help us to plan future webinars based on the feedback that we receive. And as mentioned earlier, a recording of today's session will be made available on the employers page of our website by the end of this month. And so at this time, I'll invite participants to share any final questions that you may have. You could use the chat function or the Q&A function on Zoom, or raise your electronic hand to pose any questions that you might have. And as we wait to see if any questions do come up, I'll just note that as you're working through files or preparing reports to send to the college, if any further questions come up, please feel free to contact Patrick Winter, who's the manager of intake and analytics, or Janice Duggan, who's the manager of investigations. And both of their contact information is posted on the slide that you see here. So I'll just pause briefly to scan the chats to see if there are any further questions that have come in. I'm seeing none at this time. So if you have personnel or colleagues that weren't available for this afternoon's session, I note that we are also offering the same webinar again on Thursday morning from 11 until noon. And if you'd like to receive the details for that session, please send a message to us at outreach@oct.ca, and we'll send the relevant details to you. And so with that, I thank you for joining us today. Oh, I see one question that's just come in. It reads, could you please clarify again when the advisory on hate is coming out? So maybe I'll take that. That one is, it's still in development. There were numerous consultations that occurred with various groups on that. And so there's no date at this stage that we can offer, but more information will be posted on the college website and circulated when that is released. And I'll pause again just in case there are any final questions. And if not, then I'll thank you for joining us today. And I'd also like to thank all of our presenters for guiding us through today's sessions. And thanks to you as participants as well for the thoughtful questions that you shared with us and for your attendance today. Take care, everyone.